May it please the court, my name is Lam. Together with my learned junior counsel, Miss Naren, we appear for the respondent. I will address the issue of expert evidence for 15 minutes and reserve 5 minutes by way of rebuttal. My learned junior will address the issue of dolly incapax for 15 minutes and reserve 5 minutes for rebuttal. Your Honor, we're here to submit that the evidence provided by Dr. Lung at trial was in fact admissible and that the judge was correct in admitting this evidence. I will address the issue of admissibility in 3 submissions. First, Dr. Lung has specialized knowledge and qualified as an expert to give expert opinion about witness credibility. Second, the opinion given by Dr. Lung at trial was wholly and substantially based on his expertise. Third, the opinion given by Dr. Lung cannot be excluded at the court's discretion because its property value wasn't outweighed by the unfair prejudice to the accused. Your Honor, both Section 79 and 108C of the Evidence Act provide exclusion to the opinion rule and credibility rule to allow a party to call for evidence of a person if it can be established that the person has specialized knowledge based on his experience, training, or study, and that the opinion given by the person was wholly and substantially based on his specialized knowledge. In my first submission, Your Honor, we submit that Dr. Lung has specialized knowledge. In the case of Clark and Ryan, High Court case, page 419, a specialized knowledge is a knowledge about a subject matter that an inexperienced person is unable to form a correct judgment due to it require the assistance of science formed based on previous habit or study. In addition, specialized knowledge where the word knowledge was defined in the case of R and Hin Phuc Kang, the New South Wales Court of Appeal case, in paragraph 138. That is a knowledge that more than unsupported belief or just personal speculation. Dr. Lung gave evidence at trial about a general behavior of a child sexual assault victim, which explains the reason why a child may accommodate the sexual abuse, why a child may delay disclosure of the abuse, and why they continue to interact with the perpetrator after the abuse. These evidence, this knowledge is unlikely one that an inexperienced person capable of forming. Dr. Lung, in another hand, is an academic professional. He has 25 years of research about criminology, about the behavior of a sex assault victim. He's been a lecturer at university teaching criminology and social legal studies. He has qualification in criminology and psychology. He published hundreds of articles and books about the effect of the sexual abuse, child sexual abuse. Based on this list of qualifications, it is unlikely that the knowledge that he formed about the behavior of child sexual abuse victims is anything that falls into the category of unsupported belief or personal speculation. We therefore submit that Dr. Long has specialized knowledge in this field. I will now move on my second submission, Your Honor, that the evidence that Dr. Long provided at trial is wholly and substantially based on his specialized knowledge. In H.G. and the Queen, an opinion given by a psychologist was rejected by the court because the opinion is not based on specialized knowledge, but based on a combination of speculation, inference, personal or second-hand views, or a process of reasoning which went well beyond the field of expertise. Applying to the facts in the issue, Dr. Long's evidence was not anything to do with speculation or personal view. It's entirely based on his substantial research about the sequelae of child sexual abuse and his findings of the relevant published research by experts in the field for 25 years. The finding provided that the child under the sexual abuse may behave in a variety of ways during and after the abuse. Dr. Long also conducted field work on this particular subject, including empirical experiments that including interview and survey of the actual victims of child sex abuse. With that, we submit that the opinion given by Dr. Long at trial was in fact wholly and substantially based on his specialized knowledge. Excuse me. I will now move on to my third submission, Your Honor, that the evidence given by Dr. Long at trial should not be excluded. Section 137 of the Evidence Act mentions that the court must exclude the evidence if its probative value is outweighed by unfair prejudice to the accused. But the test in R and Harker clearly state that it is not sufficient to just conclude that the prejudicial value of the evidence outweigh its probative value without indicating which one is the prejudicial nature of the evidence and why the probative value of the evidence must be rejected. Also not adequate reason to just conclude without explaining why the prejudicial value outweighs the probative value and why the prejudice effect cannot be cured by giving direction or warning to the jury. In fact, in R and M case, at paragraph 121, it is more often in the case that the judge will provide directions or instructions to the jury to minimize the prejudicial effect rather than completely excluding the evidence. It's entirely possible for this case that if any prejudicial effect, then it is possible to just provide the jury with instruction or direction. However, we submit that in the current case, the evidence provided by Dr. Long has substantive probative value and no prejudicial effect. In this case, per Moot clarification D.2, there were no eyewitnesses, there was no other medical or physical evidence given at trial. The entire case based on the complainant's evidence, and therefore Dr. Lung's evidence regarding to the complainant's credibility is the most crucial element in this case. We also submit that there is no unfair prejudicial effect of that evidence because the evidence itself, unlike evidence by a lay witness, which given the about fact, this evidence is just a general matter within a particular area of expertise. The evidence of Dr. Lung is not established that the complainant is telling the truth, but it established that the complainant's behavior was not a demonstration of untruthfulness or dishonesty. By reference to the common pattern of child sexual assault victims' behavior, otherwise asserted adversely by the defense counsel. The evidence is purposed to restore the complainant's credibility to a neutral balance, otherwise misapprehended by the jury following the effect of the defense counsel attack on the complainant's credibility. For the reasons stated above, Your Honor, we submit that evidence should be admitted, and with that, I concluded my submission. My learned junior will now continue with the issue of Dolly Incapax.